Good afternoon, everyone, and thanks for joining us on this Friday before the long weekend. I must say it's possible that a number of the folks who signed up for this forgot it was a long weekend before they registered. We do have about maybe about a half of the folks who've registered have chimed in so far. Hopefully, the rest of the registrants can make it. But in any event, still a fairly well-attended event. We're pushing almost 70 people now are listening attentively. What's interesting about this is that if there's anything true in labor and employment law, it's that the law is constantly changing, and as HR professionals, as employers, as employers counsel, we have to ensure that we're updated and continually keeping our ear to the ground on changes in the field. And during COVID, it's almost like that requirement. You need to be on steroids to stay abreast of all the changes that have been happening. I will be discussing a change that happened in Ontario just yesterday, which affects the law that was supposed to change effective today before yesterday. So I'll go through that momentarily. But for those of you who aren't familiar with our firm, we are a boutique management side labor and employment law firm. We specialize in representing employers only in all HR matters, essentially, from health and safety to human rights and employment, construction, and labor relations. So if it has to do with employees, you can probably give us a call and we can probably give you a hand. During COVID, we've been doing our best to keep you and our clients up to date on the ever-changing landscape. And today in Ontario was supposed to be the last day of a deemed statutory leave of absence. So everyone in Ontario who at least was governed in their employment matters by the Employment Standards Act, if they went on a layoff at any point since the beginning of the year, that entire period, if the layoff continued as a result of COVID, was deemed retroactively to be a leave of absence, protected under the Employment Standards Act here in Ontario. And the government extended the emergency declaration a couple of times, but the deadline for the last more than a month, almost a month and a half, 2 months now, was today. Today was the last day that these layoffs, which were deemed into leaves of absence, were going to be leaves of absence. And effective on Monday, everyone was either going to be on layoff, or you had an obligation to return them to work or to terminate their employment if you couldn't return them and you didn't want to put them on layoff. The government has now announced that they've extended that until January the 3rd, and they did so yesterday. So as much as I think some employers will appreciate this change, as it means that they won't have to, drop an anvil on any of their employees as we transition the economy back into a sort of a more normal, if normal is a thing anymore, style of reopening. But most of my clients who I've been assisting through this process have already communicated with their employees based on the assumption that the law, as it was yesterday, was going to take effect as of tomorrow, which is now today. So unfortunately, this means a lot of employers now have to communicate with an already confused group of employees. And it would be nice, this is sort of just me grumbling, I suppose, it would be nice if we had a little bit more notice than the day before the end of a deeming period that the government was going to make these sorts of amendments, whether you believe they're helpful or not. In terms of these updates as they stand across the country, well, maybe I'll talk about that in a second. One thing I just wanted to go through for those of you who haven't used our platform before, this GoToWebinar platform, you should see a little arrow which allows you to type in a question. You hit send, it'll go into a queue, which we will answer at the end of the presentation. If you don't see the queue, there may be a plus or an expansion symbol that you need to click. And if you don't even see that, there'll be like a little orange arrow up at the top. Click on that, and then the window will be expanded and you can ask your question. But in terms of these, this was just announced by the government yesterday that the ESA is being amended this way. Across the country, they've taken different approaches to this. So in British Columbia, they have not extended the period, but as was the case before, and they've simplified the process now, employers and employees can agree to apply to the government for a variance, it's called. so that the normal period of temporary layoff can be extended once you have approval from the government on a variance. And in BC, if you already know the date on which you plan to return people to work, that variance can be applied for very easily online. So that's how BC has taken this. Otherwise, they extended their layoffs only until August the 30th. And so those layoffs were deemed leaves until August the 30th. But after that, you're going to see a series of terminations of employment unless you apply on consent to extend the leaves, the layoffs through a variance. In Alberta, they extended the layoff period to 180 consecutive days on layoff if the layoff is related to COVID, but they have not deemed these to be leaves of absence. They're still layoffs, and there's no news on whether that's going to be extended again. At least I haven't heard any yet. Another example in Manitoba, typically there only 8 weeks in 16 is a permanent layoff and becomes a termination. They introduced legislation similar to Ontario. March 1 forward, those dates on layoff don't count toward the 8 weeks in 16. And then that continues until the end of their declared emergency. And they recently announced that that would be extended until September the 14th. And they've been extending it almost on a monthly basis for a while now. So, similar to Ontario, employers there have to keep a close eye on the government announcements because they keep announcing these things at the last minute. The general legal overview before we launch into what are a series of scenarios, because we wanted to take a more practical approach to this presentation than we sometimes do, and really just give you some of the questions we've been seeing and what's been at the back of the minds, I think, or the forefront of the minds of most of our clients. Recalls to the organization. You have to think about what the basis for your recall decisions are. So if there are a number of people returning from leaves, returning from layoffs, who may be on protected leaves under employment standards legislation, you need to ensure that you don't select someone for layoff or select someone over someone else in a manner that would violate their employment standards rights, for example, or their human rights. And we'll talk a little bit about that as well. Due diligence and occupational health and safety, issues on returning people to work, concerns about health and safety, the obligation across the country for employers to take all steps reasonable in the circumstances to protect workers. These are things that employers must, of course, keep in mind. We're going to address those through the scenarios, but we're not going to give you today an overview of all of these different areas of law. Of course, certain provinces and the federal government and health authorities have been giving recommendations, indeed even in Ontario and some other provinces, recommendations that are sector specific about the sorts of protocols and health and safety precautions and PPE that employers ought to be putting in place. Those are not obligations, of course, unless they're written into a statute, but one thinks that due diligence obligations will be interpreted, that obligation to take all reasonable steps, all reasonable precautions, will be read with those government recommendations and standards in mind. And of course, on reopening on issues like we're going to discuss today, attendance management, return to work, and things like that, there's the human rights obligations to accommodate people if they have family status, disability issues, age-related concerns, anything that falls under the provincial human rights legislation. So without any further ado, let me launch into our first scenario. So this is an employee who has been working at home since the pandemic started. The employer has decided it wants employees to start coming into the office 3 days per week. One employee states that he is not able to return to work because he has decided not to send his 12-year-old daughter back to school because it isn't safe. Is the analysis any different if the child is uniquely vulnerable to the virus? What can the employer do should the employer have a policy? So let's talk about this. Schools across the country are reopening. In some provinces, they've already reopened and already had a resurgence of cases. Quebec is an example of that, although they haven't decided to close schools carte blanche across the provinces yet. They're dealing with it on a case by case. Ontario is scheduled to start reopening schools in the next few weeks, a week or two, and they're going to roll that in. They're giving parents the right to choose between remote schooling or school back at the in-person learning scenarios. Now, this issue about whether it is safe, This is not a health and safety issue for the employee, right? So if you read this carefully, this scenario does not mean that the employer says that them going back to the workplace raises a health and safety concern under health and safety legislation for workplace safety. Instead, this is more of a question about the safety of their child, which may engage human rights protections. And so the first question is, if their child is just a child like any other, and the province in which and a city in which they're going to be returning to school has deemed that certain protocols are the ones that are necessary, and putting those in place, they believe that the risks have been mitigated sufficiently to allow students to return to work, can an employer choose not to send someone back to work? Now, I think that the issue here is that there is no case law on the difference between a preference and a requirement from a family status point of view when it comes to a pandemic, and whether the legal obligation to provide the necessities of life and keep your child safe is or is not engaged because of a perhaps more subjective fear or objective in some ways fear that the protocols in that jurisdiction are not sufficient to keep the child safe. So I think the issue here is that we need to take this on a case-by-case basis. It may be that we have the right to require employees to return, but I would think that in this circumstance, if you were to threaten employees with termination, if they don't, that may be risking a reprisal or a violation of human rights. And I don't think that changes. It just becomes more complicated and more fraught with peril if the employee is uniquely vulnerable to the virus because they have immunodeficiencies or they have some other pre-existing condition. So in the circumstances, I think step one, you try to work with that employee to allay their concerns. Step two, you consider giving them an unpaid leave of absence and not turning them off, and then they can apply. And if they get EI, so be it. If they don't get EI, so be it. You ensure that they maintain regular contact, and you deal with it from there. So I think that's really all one can do. We don't have case law at this point that confirms that feelings that it wouldn't be safe is akin to a preference which an employer doesn't have to accommodate. And until we have that case law, I do believe it's a risk. So in the next piece here, we have a few questions that maybe I'll pose to Ryan. So using that same scenario, Ryan, what if the person in question was an elderly parent? They have an elderly parent who lives in their home, but they have no underlying health issues. It's just that they have an elderly parent. Do you think that changes things at all?
Well, I mean, I think it makes, I guess, for a slightly stronger case than just the one involving the kids, because there's certain comorbidities associated with COVID-19, and certainly someone who's the elder part of the population is at a higher risk statistically than people that are younger. So, I mean, certainly there'd be some, there would be, especially because that and the person is living in the employee's house, right? So that is presumably, but I don't think it matters why they're living there, whether it's just because they're living, as often multi-generational families often do, or it's because the person's being cared for. I think it increases the likelihood, especially given the theoretically time-limited duration of the COVID-19 crisis, one would hope, that there's probably a better argument for the employee in that circumstance to accommodation.
But does that change at all if the person that we're concerned about is a family friend, so close as a family friend that they consider them to be their aunt? You know, you often call auntie or uncle for a close family friend.
Well, I mean, it could potentially, Jeremy, potentially at least under a human rights code analysis. I mean, like a family friend is not a part of the family, but we have to understand that theoretically, but we have to understand that the Human Rights Tribunal does interpret these things broadly, so that there may very well be a finding that this person views them as family, and that's what family means. There hasn't been, unlike disability, where there's been literally hundreds and hundreds of cases litigated about disability accommodation and what is undue hardship. There is very little family status litigation. Courts and tribunals across the country have disagreed on what family status means, what the underlying accommodation obligations are, and none of them have considered it in the face of the pandemic. It's the same kind of issues that family courts are confronting now with disputes over parents, taking kids back to school. There was a recent decision of Superior Court on that, But I mean, we're going to see a flood of these, and they might not always be consistent. So it arguably could be different, sure.
Okay, but what about a cherished relative with no serious underlying issues, who doesn't live in the home, but they want to, presumably they want to be able to visit with this person. That's part of their cohort, their close circle, that's permitted to have contact.
As we always have to say when we're talking about something that's new with litigation, I mean, ultimately the reason there is litigation is two different parties have two different views of the law. There are no bright lines or safe harbors. But putting on, my prognostication hat is what's part of what we have to do is analyze things. This is a little different, I think. This isn't someone who's living in the home, and seems much more like a preference to me than it does with someone who's living there. I mean, you don't have to see this person. You may, I mean, I'm not saying that it isn't possible, particularly if there's some unusual facts that are present that a tribunal might see it differently. But that, I mean, it's not that might be considered an undue hardship. I think of all the fact scenarios we put out, that one is probably one of the ones I'd rather have if I were litigating this for an employer.
Fair enough. So I got another one here, which Ryan, did we agree you would handle this one? I think we might have, yeah?
I would handle this one. Okay.
All right. How about I pass the conch?
All right, so this is the come to work scenario that is something, especially for those of you that are based in Toronto or other urban areas where it is more common for people to come to work by means of public transit, whether that's the subway system or the rail network on Go Transit or public bus, whatever it may be. For some of you, there are very few of any of your employees coming on public transit, given the significant disparities in access to public transit between urban areas and not. But an employee, the scenario we have, an employee based in downtown Toronto, as urban as you get in Ontario, is refusing to come to work out of fear of catching the virus on public transit. The employee indicates that she is willing to come to work if the employer provides a parking spot for her. Does the Human Rights Code or law otherwise obligate that employer to provide a parking spot? Again, I mean, I'm going to throw away our usual comments that there are no bright lines or safe harbors, but in this area of the law, I mean, much like with workers' compensation not covering people's regular commute to and from work, commuting to and from work is not conventionally considered part of the workday. There has been some human rights case law, particularly a case I recall involving Toronto community housing, dealing with an employee's ability to access a particular work location as part of an accommodation process. But a standard situation of someone reporting to work where they do is not something that's really within the control of the employer. And in my view, I think it is quite unlikely that the Human Rights Tribunal would conclude, or a court would conclude, that an employer has an obligation to accommodate to the extent that they must provide a parking spot and pay for it. I think what I imagine would happen is the court would probably say, the tribunal would probably say, or an arbitrator, whoever it may be, that if you want to, that if you're just, I'm also assuming this is just a regular employee with no particular vulnerability, that may just particularly say that this person, that if you want a parking spot, that's fine, but it's not on the employer to pay for that. If you feel you're at risk by taking public transit, then you have to find some other way of getting there. And much like you have to pay for your bus pass, you got to pay for your parking spot. No one can ever be sure what's going to happen, but that's where I think it'll go.
Interesting, Ryan. So I guess another issue that comes up quite often is the issue of PPE and what an employer is prepared to provide and what an employer is required to provide. So in this scenario, we have an employee refusing to return to work on the basis that this employer, and it may or may not be relevant, this is a manufacturing facility, is not requiring all staff to wear specifically N95 fitted masks, those the fitted masks which were in such short supply. The employer responds by telling the employee that such masks are not necessary where social distancing is possible. So now the employer advises the employee that he will be fired for just cause if he does not come back to work. Can the employer legally do that? What are the risks? Now, let's talk this through. Okay, so we've got an employee, and in this situation, we don't have anything in the facts that suggests this individual is particularly vulnerable to anything. But what they are saying is they believe that coming back to work without this particular form of PPE is unsafe. And they're doing so on the basis of an objective, presumably, possibly a little bit subjective belief that N95 masks are the PPE that is required to keep them and their coworkers safe. The employer, of course, has looked at the medical information being provided from Health Canada, et cetera, and has concluded that masks are useful where social distancing is not possible, but that where you can maintain 2 meters in distance and there's decent ventilation, masks may actually not provide any additional protection and may, in fact, in their use and storage and maintenance issues, may actually give rise to new risks. So maybe that's where the employer is coming from. But the rubber hits the road when the employee says, I'm not coming back. And the employer says, well, now what? So I think that you have an obligation here to look at the heart of this. And even if the employee has not advised this is a health and safety refusal to work under applicable health and safety legislation, that's exactly what this is. And so I certainly would not be threatening to fire an employee for cause just because they don't want to go to work. If you can accommodate a unpaid leave of absence for this employee, you might want to offer that to them in the circumstances, though I don't think that's necessarily your obligation at this point. If you're not prepared to offer that leave or they won't take it, then in my view, you have to treat this like any other work refusal under the applicable health and safety law. You actually have to engage in a work refusal. You have to ask the employee to advise what their objective basis is for their concerns in a health and safety situation like this. And then if you determine that their concerns are not valid, you follow whatever your jurisdiction requires. So in Ontario, you would then contact the Ministry of Labour, and then they would get involved in the work refusal and they would make a determination. Anecdotally, because most of these cases have not been going to court or to the Labour Board, I can tell you that in almost all cases where employers, to our knowledge, have been following the health and safety protocols and recommendations of Health Canada and Ontario medical practitioners, the Ministry of Labour has been denying these work refusals and has been finding that employees indeed do have to go back to work and that it's not a health and safety risk. And so in that circumstance, once the ministry has confirmed that you're right and you are now satisfied that you followed the law under health and safety, now I think you're in a better position to say to the employee, look, we're not trying to force you. If you can accommodate a leave, do so. But if not, you just say, we need you to come back to work. And if you're not prepared to come back to work, your job may be in jeopardy. And I think at that point, you're relatively safe from an allegation, successful allegation of reprisal. Bear in mind, of course, that most jurisdictions, including Ontario, provide employees and employers with a period, 30 days or shorter or longer, depending on the jurisdiction, to appeal the decision of a Ministry of Labour inspector in a work refusal. So keep in mind that they may go to the Labour Board and get a new decision, which may or may not have an impact on what you've done by terminating their employment or threatening to do so. Brian?
Hi. All right. So we have, this is the cross-border scenario, which has been coming up a fair bit. And when presumably the rubber will hit the road on this once the current restrictions that restrict travel to the United States to essential purposes and anyone coming from outside the country from anywhere else is subject to a strictly enforced 14-day quarantine. And from certainly what I've heard from those who've been through it, that there is follow-up with cell phones and stuff. So basically, the question happens: well, what are we going to do if the border restrictions are open and the employee doesn't want to go to the States? We have an employee who regularly traveled to the U.S., has told her company that she will not be returning to the United States once the border is reopened due to her fear of catching the virus. Travel is an essential part of this employee's job. Can the employer require an employee to travel to the U.S. once the border opens to non-essential travel? Well, I mean, I think that how one looks at the analysis of this is one is going to have to assume that if that's the case, the government of Canada has concluded that it is safe to cross the border. Further, I think one's going to assume it's not going to be carte blanche like it once was, as long as the COVID-19 fears are there. There's going to be perhaps some sort of instant testing at the border before someone goes in. But that being said, if it's objectively true that the COVID-19 situation is still it's still different and more significantly widespread in the United States than it is in Canada, I think that you as an employer might have a difficult time insisting that someone go to the United States. And that, I mean, it may very well be that is a legitimate reason at some point that, I mean, that this person can't do the job, that it basically becomes almost a frustration of contract in a way. But I mean, that would be a long, long way from there. So I think that when you're looking at this, I don't think that employers should assume that the second that the border reopens again, you can start requiring your employees to go to the States. It's going to be an individualized assessment. It's going to be based on what the objective situation is. We've had one case sort of dealing with an issue like this that I referred to on our last webinar, dealing with an individual who worked in Sault Ste. Marie, Michigan, but commuted to Sault Ste. Marie, Ontario to work in a manufacturing, to work in a facility. And ultimately, you know, the employer didn't want him to live in Canada during that period. And he said, no way, I have kids there. And he is permitted as a matter of, as an exemption to cross the border to work without being subject to the quarantine requirements that everyone else is. So the arbitrator in that case concluded that you know, that you could appropriately accommodate the employees. So I think anyone that runs into an issue like that is going to want to get some legal advice on it. It's a very complex and fact-driven exercise. And the answer to it, as the arbitrator himself in that decision dealing with the Sault Ste. Marie situation said, you know, the reality can change depending on how things go. And we know that, you know, at least as it stands now, there is a significant number of more COVID-19 spread in the United States in many areas than there are in most of Canada.
Thanks, Ryan. So our next scenario here is an insurance company that implements a policy that all employees must download the Government of Canada's COVID Alert app to their phone. Now, for those of you who don't know what this is or who haven't downloaded it themselves, essentially what the government did, and it took them a while to develop this app, is they have this COVID app which integrates health information in what they have said, to the extent you believe them, is in as essentially anonymous a way as possible. And they do this with you know, different codes that change over time, with codes that you get should you ever test positive that you then enter in to the app. And what the app is supposed to be doing is, if you have the app and someone who's within a certain distance of you has the app, then over a 2-week period after you guys have been in contact, if you or that other individual tests positive and takes the time to take the code that their doctor or the testing facility gives them and enters it into the app and sends it into the government's anonymous cloud, then by pairing these numbers, they're able to anonymously identify everybody who has a phone who's been in contact with someone who had that phone and was tested positive. And so you're not told who it was or where you were, but you're told that you were potentially exposed and that you should go get tested. And so the employer, just to be clear, probably is not going to be getting access to any of this information through the app. I'm not an IT guy, but my understanding of what the government is that even the government can't get access to the individual identities without consent. So for what it's worth, in this case, an employee is refusing to download the app. And they're claiming it's a breach of their privacy. What can an employer do? Well, I think the answer to that question is they can probably, and this is, I'm putting air quotes around it for a reason, probably require employees to install the app. They probably cannot require them to keep the app on their phone when they're not at the office. And they probably can't require employees to carry their phones with them everywhere they go. And they almost certainly cannot give the employer access to the information that's on the app without there being an issue where they've perchance tested positive or been exposed, and they have to advise the employer for other reasons. The other thing I'll mention is, of course, that every jurisdiction is different when it comes to privacy. So you may, for those privacy buffs out there, you may be aware that the government of Canada, this has to be 15, 16 years ago, released PIPEDA, the Private Information, Public Information. I forget what the acronym stands for. It's been so long. But the PIPEDA is a federal piece of legislation that governs privacy, and it governs it in a commercial context, and it governs it in a number of other contexts in terms of government and quasi-government organizations, but it does not cover employment expressly. And when the government enacted the PIPEDA federally, they gave each province the right to enact their own legislation that deals with privacy. And then that legislation, not the federal government's legislation, would cover matters under provincial jurisdiction, such as employment. And so a number of provinces, BC being most notable, enacted their own privacy legislation. And those pieces of legislation include significant privacy protections and restrictions on the collection, use, disclosure of private information in the context of employment. Ontario is not one of those provinces, and so technically there is no Privacy Act that would, in my view, prevent you from requiring your employees to do this. And of course, you might want to consider whether this is a permissible requirement under a collective agreement. If your employees are unionized, that may be something else entirely as well. So the bottom line is, most likely you can require people to download it. Most likely, in my view, regardless which jurisdiction, you can most likely require employees to have it turned on while they're in the workplace as a reasonable precaution to protect your employees. But in my view, you probably can't go beyond that. And that some jurisdictions, most notably BC, you may need to get some legal advice to confirm that that advice holds there. Ryan?
All right, so this is another scenario I think a number of you are probably going to be dealing with. An employee has a child with an immune system disorder and has been working at home since COVID-19. The employer asks him to return to work in the office. The worker indicates that he cannot because of the risk to his child. He indicates that he is allowed to continue. He asks that he be allowed to continue working from home. The employer indicates that everyone has vulnerable people in their lives and instructs them to return to work. The employee responds by threatening to file a human rights case. What will happen? Well, I think most of you know what will probably happen if you file a human rights case in this situation. Clearly, we have a uniquely vulnerable child. We also have someone who has been working at home in the during the crisis. All of a sudden, perhaps the scenario doesn't set out the reasons, but the employer says that he wants to get that person should go back home. And saying everyone has vulnerable people in their lives. Well, that's not true, of course. Certainly not everyone has a child with an immune system disorder, which of course is uniquely vulnerable to COVID-19. So I think if you're an employer, you better have a darn good reason as to say why this would possibly be an undue hardship to return this person to work. And I would have a difficult time imagining how you could advance that argument, in my view. So, from that perspective, I think that that kind of employee is not in the same situation as everyone else from that perspective.
Thanks, Ryan. So, got another situation here. This is a private school is conducting in-person learning for all students. And this decision has been very controversial with some of the staff. This might be ringing a bell for some parents who are listening in, and for anyone following the news. During the first 2 weeks of school, there's been a significant increase in the rate of absenteeism, which the principal believes is related to COVID-19. And when we say absenteeism, we're not talking about schools, children being absent. We're talking about teachers, right? What can the school do? Could this be considered an unlawful strike in a unionized setting? And this case is actually modeled on a similar situation, which was actually litigated on an urgent basis, and which we discussed in our last webinar, where there was ongoing negotiations happening in a long-term care home, and a number of employees engaged in essentially not really a sick-in, but they all agreed not to accept assignments that were ordinarily something that the schedule would accept, and then they decided not to accept these assignments. And then this long-term care home decided that in order to fill the gaps and keep their program running, they had to hire from an agency. And then the union grieved that this was all a violation. And ultimately, one of the issues that was buried in that case was the question of sort of the health and safety issue here. So many of you will be aware that a number of significant Ontario unions, for the four largest, frankly, in the public sector, have all initiated a challenge under health and safety alleging that the protocols that the government has put in place for the in-person learning in Ontario schools is unsafe. So this is a health and safety application. My understanding is that that is working its way through at the Labor Board. I haven't been able to get a copy of the pleadings as yet, but this is what would happen afterwards. So let's make the assumption that the teachers with their application are either successful and new protocols are put into place, or they're unsuccessful and the schools open with the protocols that have been determined by the Labor Board to be sufficient under the Health and Safety Act. And then you have sort of these absenteeisms, these random groups of people who just happen after that Labor Board decision to unilaterally decide that they're not going to be coming into work. You get a whole bunch of people calling in sick, you get people applying for leaves, you get people with no call, no shows. Is this a concerted activity? Is the first question. And so if it is a unionized setting, and these are a number of individuals who on a concerted basis, with or without their union's prodding or condemnation, are doing this essentially in protest to what the employer has been found to have a right to assign them work under the collective agreement, which has been found healthy and safe within the meaning of the Health and Safety Act and their collective agreement, could this be an unlawful strike? At that point, it very well may be, if they're not during the open period of their collective agreement. So the two issues here are the health and safety aspect of this. And so individually or even as a group, if there are a number of employees at a school or anywhere else who are saying it's unsafe to return to work, going back to our earlier example, we should be considering this to be a work refusal. We should go through that process as per the legislation in the jurisdiction where we're working. And if we can't settle that dispute internally, then we have to follow the work refusal provisions of the legislation in our jurisdiction to their conclusion. And that will include, in most jurisdictions, contacting the Ministry of Labor for an officer or inspector to get involved. And then once that decision is made, potentially there are appeals up through different processes and tribunals. And so that I think we have to keep an eye on. But again, if a determination has already been made and the facts are not new, well, then we're probably looking at a situation where we may have indeed an unlawful strike. Whether or not an employer wants to ring that bell and file such an application, when at its heart we may be dealing with a health and safety disagreement, is something else. But a grievance under a collective agreement would be optional. A health and safety application to the Labor Board to get a confirmation of whatever work refusal process was concluded with an inspector's involvement, and ultimately this may expose employees to terminations, to discipline for unlawful strikes and for unlawful refusals to work. But there's a process there that we would all have to follow. So without any further ado, Ryan, I guess we'll get to the questions. If you folks haven't had a chance to put your question up yet, then now's the time. And once we have those, as the questions come in, we'll do our best to respond. Bear with me a moment. I'm just going to pull up the question pane. Okay, I think we've answered some of these questions. So just bear with me as I review them in real time, everyone. And we don't have a lot of questions here. So again, if there are folks out there, we've got about 100 people still on the call. So if you have not had a chance to send in a question, please do that. So the first question, so what if we're dealing with, and it's not clear which question or which scenario this question is coming from, unfortunately, but if you have if you have an individual who has someone at home who may be more likely to contract it or have more serious, maybe this is a good question for you, Ryan. If you have, if the employee has someone at home and their concern is that they're vulnerable, but this employee is working in a healthcare setting where perhaps they're being expected to take greater risks than the rest of us of contracting and bringing that home, would that alter the analysis in terms of whether or not you need to provide someone with a leave of absence or provide some other forms of accommodation or PPE?
That raises an interesting question. It depends upon which legal banner you're looking at it under, right? I mean, in terms of first of all, under work refusals, I mean, we've discussed this in other webinars, but happy to revisit the work refusals have exemptions to them, right? And in some cases, those are people that are working in healthcare facilities, essentially emergency workers in certain situations that are exempt from the work refusal provisions of the Occupational Health and Safety Act and have been for some time. But I mean, if one is looking at this from sort of the accommodation human rights lens, it's not like there's no exemption for healthcare. And I mean, it's one of those things that becomes kind of a tricky issue, right? There certainly has been case law in the work refusal area that people that are in, even for the non-exempt parties, that where the job has an inherent risk to it, there's an inherent risk to it. But and then there's an element of that when that's inherent in the job. But from a human rights perspective, when I think you're saying that someone is uniquely vulnerable, and that I'm not sure the tribunal is going to agree that there's some sort of greater voluntary assumption of risk in the context of COVID-19. But certainly, I guess there might be a better argument. But I would not expect the Human Rights Tribunal to say that there's a greater voluntary assumption of risk in terms of that issue. But you know, it's interesting to see what happens with it.
Thanks, Ryan. We have a question which came early on, but it's again not clear which scenario this relates to. But there's a question about whether someone would qualify for infectious disease leave in various circumstances. So I think the thing to do is, regardless which scenario this relates to, we have to keep in mind that in every jurisdiction there are different emergency leaves, there are different standard leaves of absence, which continue to apply as well. And we have to look at the circumstances for which the employee is saying they're unable to return. We also have to look at whether the statute provides any entitlement for an employer to request medical verification or other evidence reasonable in the circumstances to demonstrate entitlement to these sorts of leaves. If you have an employee who has a preference and they don't feel safe, and we've gone through the health and safety, workplace work refusal provisions of that sort of segment of the regulatory scheme, and you still have someone who's saying, I just don't feel safe, but they have no underlying health reason for not returning to work. Well, this isn't a leave, right? This isn't a circumstance where there's no work available for them as a result of COVID-19. This would not be infectious disease leave if they're refusing to work. It's either a valid work refusal on one hand, or it's not. Ryan, maybe this is a good one for you. Is there any guidance on the requirement to provide additional expenses? I guess is the employer going to be required to foot the bill for internet, furniture, any requirements to allow people to remotely work?
That comes down to be a very interesting. That comes down to be a very interesting question, right? Like we addressed the scenario, Jeremy, about the parking spot, and I thought that was fairly clear. I mean, you know, you're expected to pay for going to work, and if you've chosen to think it's safer to take your car, that's fine. But I mean, an employee is saying, and there's obviously, like previously, would there be some obligation to pay for an internet service in the absence of a contractual obligation to do so? And like, you know, it may very well have been that the employee, I'm guessing in most people's case, has home internet service. But yeah, I think there may very well be, it could very well be that that the court might say that it's an implied obligation for the employer to pay for that, the employer to pay for that internet service if the employer is requiring the person to have that as part of their job. There might be another argument that says, well, the employee had it anyway, and it's not in the employment contract. But I mean, I think, yeah, there could be some there could be some argument to that effect. But remembering, I mean, because most employment contracts aren't in writing, right? And so you have to look, so it's sort of an implied term, and someone might say it's an implied term for the employer to pay for internet, particularly where if the employer is already like reimbursing for cell phones and that sort of thing. But you know, there's an argument to the other side of that as well. So I mean, it's the answer is it would be somewhat factored in. But if you're saying someone's working at home, and the best facts of the employee would be that, you know, they needed this particular internet package, didn't have it before, employer saying I need this, then that's that. There might be another argument saying an employer doesn't pay for your shirt and tie, so you know that's required for the job, so it's no contractual obligation to do it. So interesting question.
Yeah, thanks, Ryan. I mean, that's the perennial issue, right? Is you know, employers are often willing to accommodate people if there's not going to be a financial cost, and I suppose the issue here is you know, when the rubber hits the road, if the employee says, I don't want to pay for it, or I'm not going to install something, or I'm not going to do my job unless you cover this cost, is the employee quitting, or is the employer threatening to fire them? Sort of an interesting, are you imposing a new condition on their employment that wasn't part of their original agreement? Yes, it's a very
Yeah,
interesting.
I think it's pretty clear that you are. It's just a question of how a court categorizes it. Is that something like, like wearing a shirt and tie to work, or is it an additional requirement? What relevance, if any, does it have if the person had the internet service before, which most people probably do?
I think so. That's likely for any job that's able to remotely work as well.
Yes.
So now we have another question here. What happens in a situation for a duty to accommodate where the job requires a person to be at work to perform their duties? Okay, so this is the maybe I'll take this one, Ryan. This is the opposite side of the coin. So Ryan took a question before. Ryan took a scenario before where we had an individual who required accommodation and who had been remotely working during the height of the pandemic. So I'm going to make the assumption that in this question we have an individual who, during the height of the pandemic, were on essentially a leave or a layoff, depending where they were, what province they're in, and they were not able to perform the core job while they were in lockdown with the rest of us. And so I think in that circumstance, you have a situation where you're looking at the duty to accommodate to the point of undue hardship. And so whereas before you had the right for everybody to say, okay, we're going to put you out on layoff, we're going to put you out on leave, there was no obligation for employers who had the legal right to use a leave or a layoff to give remote work, even if it was theoretically possible. So if you have an employee who was not remotely working, and now everyone's coming back to the office, and this individual says, well, I'm immunocompromised, I can't come back to the office because I have a more significant risk than other folks, and I'd like to be able to work from home. I think in that case, you might have a better argument that in this circumstance, it would be an undue hardship to create the structural supports to allow someone to do their job from home. If they simply can't do it from home, we're talking about a manufacturing job in a plant, well then I think the analysis is much more straightforward. The question is, do you have any work that is outside of their position that you can consider? That doesn't mean you have to create work for them, but the human rights law has developed to the point in all jurisdictions in Canada where if they can't do the core duties of their own job, an employer may have an obligation to consider whether there are other duties, productive work, that can be done even if on a temporary basis, and you'd want to make it clear this was a temporary accommodation, not a new job, that you may have to assign them to. Now, that doesn't necessarily mean that you have to pay them more money. So if that other job is a more clerical administrative role, then and it pays half of what their manufacturing plant job used to pay, well, they only get paid for the work that they're doing, and they may not like that, but that's the law. On the other hand, if you don't have other productive work for them to do, you're not generally required to create a job, and they may be entitled instead to a leave of absence without pay until such time as it's safe for them to return to work. Unfortunately, that just may be the reality. And if that goes on for a significant period of time, you may want to discuss with them whether they would like to have a package in exchange for a release. And if not, then they'll remain off on a medical leave of absence and they'll apply for EI if they can get it, and so be it. So here's maybe the other side of this coin, Ryan. Maybe you can take this one. What happens if an employer breaches the human rights code? Can an employer be ordered to allow an employee to work from home?
Yeah, here's the question. I mean, the Human Rights Tribunal has vast remedial powers, more so than a court does in civil action, where almost civil action is all about money when it deals with employment. But when it's talking about human rights, the Human Rights Tribunal has vast powers in terms of what's called remedies, the orders that it can make, which go far beyond just ordering damages, which of course remains the primary method. The Human Rights Tribunal can order someone to be reinstated to employment and on the terms and conditions that it stipulates. I mean, it has all kinds of powers to order what it calls public interest remedies, which often include, such things as having employers go through training on human rights, implementing certain policies they want implemented. So, and it's very, their remedies are much more prescriptive is a legal term, but basically go well beyond money. So sure, they have the power to do that in my view. And that's probably a remedy that's going to be sought. I mean, we don't think about it much because most human rights litigation is focused on damages, financial damages, because there's a lot of people, there's a significant small minority of people that go to the Human Rights Tribunal want to have their employment reinstated on particular terms or anything else, but it does happen. I mean, I did a lengthy human rights case with an employee who was an ongoing employee of the employer that was fighting over an accommodation right to a specific wage rate, basically, and that was a case that went on for quite some time. So it does happen. So it is possible, and this would be the type of situation where maybe somebody does want that kind of order.
Yeah, it's very interesting. Certainly, the tribunal does have these vast powers, and we want to look out for those creative remedial orders that may be coming down the pipe. Another question we have here, maybe I'll take this one. This is a scenario with an employee who has a parent in hospital, and that parent doesn't live with the employee, but the employee has been designated their sort of caregiver, their representative. Now, they're in hospital because of a heart attack, so presumably they have a serious medical condition, and they would be eligible for certain forms of employment standards protected leave, particularly in Ontario, quite substantial leave, in fact. But this question is not about whether they can go off entirely. This question is about returning people to work. And the employer wants this employee and their coworkers to all start rotating in on a 50% basis, working from home half the time and working from the office the other half of the time. The employee has asked that they be given an accommodation, that they be permitted to return to remain on their 100% home remote working basis in the circumstances. And the employer has taken the position that the safety precautions are all in place, that accommodation is not required, and that although we will accommodate this employee's needs to depart at various times in order to go to the facility, that we are not going to accommodate them working from home. And I guess what I can say here is this: although this employee may be entitled to a leave, which is not half day or 1 hour leaves of absence, like full leaves of absence to go and care for this person, I would agree that this employer has likely not violated the human rights law in this circumstance. Employees, even if their family status rights to give care and support to an ill parent does engage family status, which is possible. There is case law on that, which is still quite consistent over the last 10, 15 years, that if you have a parent for whom you're providing care, that you may be entitled to leaves of absence and other accommodations for that. It does sound from this scenario like the employer is able to accommodate the employee so they can provide that care without them being required to always work from home. And so on that basis, it does sound to me like this is an employee preference to work from home. Perhaps what's hidden in this question is that they are concerned that there may be a health and safety risk of the employee being exposed at the office and bringing or transmitting something they pick up before the symptoms appear when they go and visit their relative. That is not something that, in my view, would be a reasonable precaution. Provided all precautions are in place, it strikes me that this employer is probably doing the right thing under the Human Rights Code, and certainly could offer the employee a leave, which would be unpaid, instead. But under these circumstances, I don't believe it's an obligation for the employer to accommodate by offering full remote from work. I just don't. I don't believe that arises here. Ryan, so here's a nice one for you. How do I handle performance issues with an employee who is raising concerns about human rights issues on I guess, the return to work?
Yeah, I think that this becomes a real challenge. Like the management still has to manage, right? I mean, and that doesn't stop in COVID-19. And in fact, it can be made worse. But that's maybe for some people, for many people, working from home has been a very smooth transition, and for others, it's not, for whatever reason. So at the end of the day, I think you always have to not freeze and not make the mistake of you're not going to performance manage someone because someone has raised statutorily protected issues, whatever those issues may be, whether they're health and safety and human rights, which are the most likely scenarios that would arise in the COVID context. So what you're basically going to do, you're going to want to document the performance and also document your response to the health and safety issues. You do obviously have to be aware that everything you say, everything you do is going to be scrutinized by the employee or the union or the employee's lawyer through the lens of that you're doing this because of COVID-19. But if you have a legitimate basis for doing so, and you can prove that, then just go ahead. You still have to performance manage the person, which means that things like showing up for work on time, things like getting your work done on time, things like quality interactions with clients, production standards, whatever they are, objective measurements are best, that you're still going to want to engage in all those things. But bearing in mind, when someone alleges a reprisal, and those cases, especially in health and safety, come on pretty quickly at the labor board, you're going to want to be able to prove, and the obligation's on you, it's a reverse onus, that any action you took against the employee was not related to health and safety. And certainly, you know, and certainly we have to remember that the general duty clause applies, and much like sort of the case with the teachers that are advancing the case at the labor board, it's not about the violation of any one piece of health and safety standards within the regulations. It's a general duty to take all precautions reasonable.
So we've got one more question here. So we'll do this one, and then we'll try and see if any other questions come in the 3 or 4 minutes we have left. We try to begin and end on time for everyone. So this question is about the employer's right to request medical information. So this is sort of a perennial issue, particularly when it relates to an employee's child or someone for whom they're requesting a human rights accommodation. So keep in mind that depending on what jurisdiction you're working in, or the employee is working in, there will be some restrictions in employment standards legislation with respect to the leaves of absence that an employee might be entitled to take if they have a parent or a sibling or a child who is in need of some kind of care. But on the assumption that we're not dealing with a one-off or a long-standing leave of absence under those provisions, what we're really talking about here is a request under the human rights legislation of that province for accommodation. And the law has been consistent since the beginning of the charter that employers have the right and employees have the obligation to expect cooperation, and that the employer has the right to demand evidence reasonable in the circumstances that the employee's human rights have been engaged. That doesn't necessarily mean that you'll have the right to the diagnosis that their child is suffering from, but you would have the right to, for example, getting a medical certificate which confirms that the child suffers from a condition, a pre-existing, they don't have to say what the nature is even of that condition, but a medically verified condition that in the medical practitioner's opinion makes that employee's child more vulnerable should the parent come home with COVID and transmit it to them. So I think in that circumstance, you do have the right to medical confirmation. You don't have the right, as you would with an employee, to even know the nature of the condition. In my view, all you need is medical validation that this employee's child is one of those vulnerable people, and that the employee's concerns, which trigger the human rights obligations, are valid. And that really is where that comes to an end. Ryan, here's one, maybe the last question for you, and this one also comes up quite often. What are the reasonable guidelines, accommodation and otherwise, with respect to childcare? So specifically, what if an employee says, I can't afford it? And in order to return to work, presumably wherever it was that they were working before, there was adequate childcare available, and now there isn't for various reasons, capacity, what have you. At that point, do you have an obligation to accommodate them, and in what form?
This is an issue as old as as that's hardly new in terms of COVID-19, and it's always a difficult issue. The reality basically is, and look, the law, I think I want to be careful discussing family status, because if there's anything the law has been all over the place on in terms of family status, is sort of what the employer's actual obligation is, what an undue hardship is, what actually qualifies as a preference. I mean, a situation like this is going to depend upon evidence. Like, why is childcare not available for this person? And is there something extraordinary taking place that's, i.e. they literally cannot find it anywhere? Every daycare center is full because of COVID-19 or something else? Or is it because the costs just so outstrip what the employee can afford, that that's not something they can do? I think from an analytical perspective, I think for many employees, it's going to be an uphill battle, I think, to say that I can't afford it. I mean, at some point, I think one can say one has to, unless there's been some dramatic change that, it used to cost $10, $20, $30, $40 a day, now it costs $300 or something. If you have those kind of facts, maybe that's justifiable. But otherwise, I mean, I think that's some math that you need to probably do before you start a job. Or you may have to decide that, whether it economically makes sense for you to do that. So it becomes a very tricky, very fact-driven analysis. There may be certain cases on certain facts where they're going to say that there's an obligation that exists, but it just depends upon the job, depends on how many people are affected. If you have 20 other people with kids in that same job, and they're paying for childcare, I mean, it's all very fact-driven, and something you'd want to get some advice on. This is one of those kind of situations you don't want to go off sending out emails, because I know the natural reaction of the employers to stuff like this is like, oh, come on, everybody needs to get childcare, you just don't want to pay for it, kind of thing. And you got to be careful how you respond to that. That ultimately may very well be the answer, but being flippant or frustrated with it is not a helpful response.
All right, and so there was one final question. We're a minute over, but I'll answer it. Someone has asked if I can confirm that the infectious disease leave has been extended to January of 2021. And what I can tell you is that if as of yesterday you went on the Ontario government's website, they have a guide to the Employment Standards Act, and indeed they have in yellow indicated that the regulation has been amended. So this isn't a proposed change to the law, it has been amended. And so as of now, from March the 1st until January 2nd of 2021, anyone who was on a layoff is deemed, at least for ESA purposes, to be on a leave of absence. And so beginning on January the 3rd of 2021, they will no longer be covered by this deeming provision, and instead they may either be on layoff or ultimately deemed terminated under the statute. So if we didn't get to your question, sorry for that. We have, it looks like, gotten to the vast majority of these. And I suppose the other thing to keep in mind is that the different kinds of leave, let me be clear on this, the leave that I was just discussing is not about the general infectious disease leave provisions, which in any event of a declaration of infectious disease, if an employer has to be off because their child or someone in their household is suffering from those symptoms, or they have to quarantine, that leave under the ESA will continue to apply. It's an unpaid leave. I'm referring to the provisions in the regulation which deemed a layoff or reductions to hours of work to, during this period of time, not be a layoff or a constructive dismissal, but to instead be a statutory protected leave of absence or reduction. And so just to make sure there's no confusion there. Okay, so thanks very much for joining us. Hopefully this has been informative to everyone. Have a fantastic long weekend. Happy Labor Day, everybody.
Yeah, happy Labor Day.